Hi, hello everyone. This is V.vigneswar. I'm a law student. I'm going to explain one of the most important case in cyber law. So that case is CBI versus ARIF AZIM. So this case has its own significance because India saw its first cyber crime conviction in India, and also the important thing should notice that the case was happened in 2003 and conviction also happened in 2003. But we at the time we don't have any separate provision for online cheating and data protection. India having its own information technology law 2000, but it only covers e-transaction, business transaction, and also it only gives legal validity for digital signature and electronic signature. So it does not provide any provision related to computer related offense and online cheating. But these are the cases which drives Indian government to make laws or provision which related to online cheating and data protection, and there's a need for a separate regime to deal this case was addressed by Indian government in 2008, and further amendment was made in 2008 to address these kind of cases, and particularly they added six offences under computer related offences in Information Technology Act. So what is the case is about? So the case is about Sony Private Limited. We all know one of the multinational corporation which has its global consumers. So they filed a complaint in CBI against Arif Azim. So the main fact of the case is that Sony runs a website called sonysambandh.com. So this website is mainly covers non-resident Indians. So it acts as a bridge between non-resident Indians and their friends and families. So what the objective of such website is, if an NRI can buy any Sony appliances through website and they can send to their friends and families, and once their friends and families pay for such such Sony appliances. So this is the process which is involved in Sony website. So one person called the online identity is of such person is Barbara Kampa. She ordered a color TV and a cordless headphone, and also it was paid by Arif Azim. And after due diligence and payment clearance of payment, the product has been sent to Arif Azim, and the Sony Appliances Authority also took digital photograph by acknowledging that the product has been reached the particular person. But after 1.5 months after such transaction, the particular credit card agency said that the real owner of credit card owner denied such transaction, and it was unauthorized one. So it made Sony to complaint in 2003 before CBI. And the important thing to note is that India at the time we don't have any separate provision for dealing with online cheating and other data breach. So as I had said already, this case completely laid on IPC, Indian Penal Code, because we don't have no other go. So we should only completely rely on IPC, so which provides sections like 418, 419, 420. So what 418 says that cheating by a person which will cause wrongful loss to the person interested in the transaction, and 419 cheating by personation, and 420 of IPC clearly states that whoever dishonestly induces and deceives for delivering of any property or damaging any property, then it comes under the punishable offence under IPC. So CBI lodged complaint under these three sections, 418, 419, 420. We can see these are the offences which was conducted through means of computer, but we don't have any separate law for offences which are related to computer. So these are the instances which led Indian government to make some amendments in 2008. So what has happened in the main issue is whether the complaint lodged under section 418, 419, 420 under IPC against such Arif Azim is justifiable or not. So the case has been processing, and subsequently CBI conducted raid on Arif Azim home, and they confiscated a TV and cordless headphone, and also they obtained information regarding Arif Azim, and said that he is working at BPO, and gathered information of one American National credit card number. So by using such credit card number, he involved in online cheating. So court finally came to view that he is liable to be punishable under the section 418, 419, 420 of IPC because he satisfied all the essential ingredients. First, he is cheating caused wrongful loss to the real owner of the credit card. Also, he did cheating by personation. He pretends to be some other person and pretends that he is the real owner of such credit card. And third, he deceives and dishonestly deliver some of the property. So he deceives Sony Corporation. So he satisfied all the essential ingredients. So he will liable to be punished under 3 section of IPC. So, but what court did is that he is first convicted. He is not an habitual offender. He was not habitual offender. So the court took a lighter view on such person conviction and said that he is held to be liable for 1 year punishment, and he is released on a subsequent year after once his punishment has been satisfied by him. So what this case said to India is that we need a separate law for to deal with online cheating and online data breach. Particularly, we should have some separate laws to deal with the case because we completely relied on 418, 419, 420 of IPC. IPC, such section didn't mention about computer. So the offense is based on through means of computer, but we lodged complaint under section 418, 419, 420 of IPC, which never speaks about any computer. So these are things which create pathway to India to have amendment in information technology law. So aftermath of such these cases, we have amendment in 2008 and also we have own information technology policy in 2012. So this is the case India cites first cybercrime conviction, and also the NCR National Crime Bureau report, which clearly states that from year to year the crime which involved through means of computer has been escalating from year to year. So and also they recommended that India should have new added provision in existing laws to cover other computer related offenses. Thank you.